It's a perfect illustration of federal government overreach based on a very specific interpretation of the law. That's the argument the state of Idaho is making as it tries to argue against stopping the enforcement of its abortion trigger law. A little more than 2 weeks ago, the Department of Justice filed a lawsuit against Idaho because of its near total abortion ban. That should the U.S. Supreme Court overturn Roe v. Wade, well, it would go into effect 30 days later. Well, that trigger law was passed in 2020, and lo and behold, this June, that's exactly what the Supreme Court did. They overturned Roe v. Wade. So Idaho's ban on abortion, with exceptions only in cases of rape, incest, or where the life of the mother is threatened, well, that's set to go live a week from tomorrow. It'll be August 25th. But with that lawsuit, the DOJ wants to have that law put on pause while it works its way through the court, while the lawsuit works its way through the court. And there's a hearing to decide that scheduled for Monday, which is 3 days before it's supposed to become law. The Biden administration isn't alone in fighting Idaho's trigger law, by the way. 20 states, the American College of Emergency Physicians, and other medical groups have filed friend of the court briefs in the lawsuit, which is basically a legal way to say, yeah, what they said, or retweet. The DOJ's reason for the injunction is obvious. Why rush into something, why enforce something that could be deemed unconstitutional eventually? Let's just wait and see is kind of where they're standing. So here's why they believe the trigger law is illegal.
Idaho's law would make it a criminal offense for doctors to provide the emergency medical treatment that federal law requires. Although the Idaho law provides an exception to prevent the death of a pregnant woman, it includes no exception for cases in which the abortion is necessary to prevent serious jeopardy to the woman's health.
It's that last bit, the distinction of death or seriously jeopardizing health. That's the backbone of the lawsuit for the feds. EMTALA, the Emergency Medical Treatment and Labor Act, specifically requires any hospital that receives Medicare funding, well, their emergency department has to help a patient regardless of their ability to pay. And they have to be treated and stabilized. And that's where Idaho is pointing to say the trigger law doesn't violate that. This is kind of how they play it out in words here. The patient, legal words, so I'm going to kind of sum it up for you. The patient is stabilized within the limits of the capabilities of the staff and facilities of the hospital. That's what they're trying to say. And being stabilized, that emergency department could then transfer that patient to another hospital. The hospital, that's how they kind of get around this. Should they not want to perform an abortion, they could just transfer that patient. Yesterday, in the argument against the injunction filed with the District Court of Idaho, the state basically said EMTALA's scope is narrow, too narrow, and has nothing to do with an abortion clinic. It begins only when a person comes to the emergency department and ends when that person is stabilized. Idaho also claims its trigger law is not interfering with those EMTALA agreements, but the state is simply exercising its police power to regulate abortion, much like it would regulate anything else it considers harmful to its people through laws passed by representatives of those people. And by threatening federal funds, the federal government is threatening Idaho's sovereignty in how it regulates abortion, a power that was just granted by the highest court in the land for the first time in nearly 50 years. Judge B. Lynn Windmill will hear those arguments in person at the federal courthouse Monday morning.